Hey everyone, what happens in a divorce if one of the spouses dies during the pendency of the divorce? This is Paul with Youngblood Law, and I want to address this topic because I saw it brought up last week by a colleague of mine down in the Houston area, Robert Von Dolan. He's a divorce attorney down there, and he addressed this topic, and I think it's a good one. And it's one that we take steps to help mitigate the risk and the damage during a divorce. But I want to take a second to kind of respectfully disagree with some of his assessment. So here you go, Robert. This is for you, brother. So here's the deal. He mentioned that there are some jurisdictions that have what we call standing orders that kind of put in place some injunctive language as soon as the parties file a divorce. And one of those injunctions is you can't change your beneficiary designations for your life insurance or retirement plans. Now, I agree with that. I know that language exists in the list of injunctions that are available in the family code as to the ways to maintain the estate, right? So, changing your beneficiary designation on a life insurance policy, changing your beneficiary designation on any retirement plans at your work need to be done before you file the divorce, because once the divorce is filed, those injunctions are going to probably go in, whether your jurisdiction has standing orders or whether you need what we call a temporary restraining order that does the same thing in some counties. You're going to need to change those beneficiary designations before, because as soon as you file the divorce, you won't be able to change them after that. Right? So if you were to pass away during the pendency of the divorce, then your beneficiaries are going to be still assigned as they were before you ever filed the divorce. And so now, most people have their spouse listed. Now your spouse that you've been trying to divorce still gets all that stuff anyway, right? But here's where I'm going to draw a distinction. I'm going to respectfully disagree with Robert as to will and as to powers of attorney. I don't believe that those count as changing your beneficiary designations. A will is dictated by the estates code, not the family code. And so I believe it's against public policy to prevent someone from changing their will and writing their spouse out of their will. In fact, there's no requirement that you ever put your spouse in your will to start with. So there's no language in the family code that talks about a bar to changing your will or writing your spouse out or writing a will for the first time ever that doesn't include your spouse. I don't think there's any injunctive language in the family code that prevents that. Now, I know that there's no language in the family code that specifically talks about changing your power of attorney or your medical power of attorney. I believe you can absolutely do those things, and I believe you should do those things. And at Youngblood Law, we help our divorce clients first things first with those documents because, God forbid, we start fighting a divorce and 6 or 8 months later, our client gets hit by a bus, and now the spouse is still the power of attorney. So the spouse is going down and cleaning out the bank account. The spouse is going down, turning off the utilities and selling the house, while our client is incapacitated in the hospital. So we think that would be devastating. Likewise, on the medical power of attorney side, you would not want your spouse that you're trying to divorce, your future ex-spouse, to make your medical decisions for you. Oh yes, if he's on life support, I know that he would want to be unplugged. I'm sure of it. Of course that's what they're going to say, because they're fixing to get like all your stuff as opposed to getting half your stuff, right? So we just feel like leaving your spouse as your agent, whether on the business side or in the medical side, is a recipe for disaster. And likewise with the will, obviously it doesn't make sense to fight this person and try to preserve your estate so you can get on with your new life, and then you get hit by a bus the day before your divorce is final, and you pass on, and now your spouse gets everything anyway, right? So why don't we change your will? So I believe you absolutely can do that. I don't see any language in the family code that prevents that. I believe it's against public policy, and I believe it's against the estates code to try to restrict whether someone can change their will or not. So Robert, here it is, brother. If you can show me that language, I'm happy to see it and prove me wrong. But I believe that overall, your message is very solid. People need to plan ahead. They need to think ahead. They need to plan for the future, not for right this second. And if they need to modify their beneficiary designations or their powers of attorney or their will, they need to do all that ideally before they file. But I believe you can change those documents, at least the testamentary documents, the power of attorney and the will and the medical power of attorney during dependency, even if there are injunctions in place. So if you're looking at a divorce, get with a competent family lawyer. Find someone who knows these things so we can plan ahead for you. We need to try to protect your estate and try to protect your well-being so that you can move forward when the divorce is over. And God forbid something terrible happens to you. We want to make sure that your kids or your estate or however you want to distribute your assets are distributed appropriately, as opposed to your spouse getting everything like he or she always would if you were happily married. So thanks so much. We'll talk to you later. If you have questions, you give us a call or find us on the web at divorceinnovation.com. And we look forward to talking to you soon. Have a great day. Bye-bye.